Welcome back. Attorney Andrew Bethel here from Bethel Law, where we dive deep into estate planning, finances, real estate, taxes, and today, a topic that's a thorn in the side for many Californians and American at large, surprise medical bills and the No Surprises Act. Now, if you've ever been blindsided by a medical bill that you thought insurance had covered, or for services from a doctor you didn't even know was out of network, you're not alone. It's a widespread issue that the No Surprises Act, effective January 1st, 2022, is aiming to tackle. Let's unpack what this means for you. Don't forget to hit the like button, subscribe, share the video with anyone who's ever groaned over a medical bill, and let's dive in. First up, what exactly is a surprise medical bill? Imagine you're rushed to the ER or you're undergoing surgery, thinking your insurance has got you covered. Later, you find out that one of the providers or the facility itself wasn't in your insurance network. Your insurance might cover part of it, but you're left holding the bag for the rest, thanks to what's called balance billing. Balance billing is when a healthcare provider bills a patient for the difference between the amount the provider charges and the amount the patient's insurance approves. For example, if a dermatologist charges the insurance company $300, but the insurance company agrees to pay $150, and the doctor then charges the patient the remaining $150, the patient will receive a balance bill. These bills can show up for anything from anesthesiology to lab tests, often from services where you don't have the luxury of choosing in-network provider up front. It's frustrating and frankly an unfair aspect of an already complex healthcare system, especially when you go to the hospital for an emergency and you're more worried about your medical health, only to find out that anyone who so much as looks at you will be submitting their own bill as if you had gone and hired a bunch of independent contractors. But hey, that's neither here nor there. The No Surprises Act is supposed to be like a superhero swooping in to save the day. At least for those with a group or individual health insurance. Here's the rundown. It caps surprise bills for emergency services from out-of-network providers, meaning you shouldn't pay more than you would for in-network services. However, one key emergency service that's not covered is a ground ambulance. It'll cover you in the air with an air ambulance transport, but not on the ground. But in some states, California included, do provide some protection against balance billing for ground ambulance rides. It limits out-of-network cost sharing. So those co-payments and co-insurance rates from emergency and certain non-emergency services, they're supposed to be more in line with in-network rates. It also puts a stop to out-of-network charges and balance bills for supplemental care by out-of-network providers at in-network facilities. Think radiology or anesthesiology here. Someone brought in to fill a specialized role. Notably, this includes non-emergency services as well. Plus, it introduces a procedure for insurance companies and providers to settle disputes over charges, aiming for a fair resolution without dumping the stress on you. We'll cover that in a bit. But what if you're paying out of pocket or don't have insurance? The Act's got you covered too, with good faith estimates on the cost of care before you receive it. If the final bill exceeds that estimate by $400 or more, there's a new dispute resolution process to challenge the charges. Interestingly, if you're insured, there are situations where out-of-network providers might ask you to waive these protections for certain post-emergency or non-emergency services. They should provide a notice and consent form giving you a heads up that you're opting into higher costs for out-of-network care. But remember, you're not obligated to sign, especially if you weren't given a choice in providers. Before going further, I want to clarify exactly who the No Surprises Act applies to because we've almost danced around that question so far. As discussed, the Act applies to those with group or individual health insurance, and it encompasses all private health insurance plans, including self-funded plans. However, the Act does not apply to individuals enrolled in government programs like Medicare or Medicaid, as these programs have their own protections. There's a whole separate government apparatus to deal with those of you on those programs, which is outside the scope of what we're talking about today. Now, what if you have a surprise bill? The process differs if you're insured versus uninsured. For the insured, you can appeal claim denials through your health plan. For the uninsured, or if you self-pay, that good faith estimate becomes your shield. Billed over $400 more than estimated, time to engage in the dispute resolution process, the Federal Independent Dispute Resolution Process, or the IDR process for short. It's a process to resolve disputes between plans, insurers, and non-participating providers and facilities. The process is used when the parties can't agree on a payment amount for out-of-network services and items. The IDR process requires payers to make prompt payment to out-of-network providers and facilities. The providers can challenge the amount if they think it's inadequate, and if the payer and provider cannot agree, then each party offers an amount. There must be early communication, usually from the payer with their initial notice of denial of payment or an initial installment payment. There is a 30 business day open negotiation period, and there must be the ability to include multiple items or services as separate payment determinations in a single dispute, as in we can argue anesthesiology and radiology in one dispute. Additionally, the initiating party must submit a notice of IDR initiation through the federal IDR portal on the same day it's submitted to the non-initiating party. The idea is to ensure fair payments by using an impartial third-party arbitrator. However, as of June of last year, only 39% of submitted disputes have been resolved, leaving 61% unresolved, which comes out to around 300,000 disputes. So, not a fast process by any stretch of the imagination. Still got questions or need to file a complaint regarding the No Surprises Act? You can reach out to the Centers for Medicare and Medicaid Services No Surprises Help Desk or submit a complaint online. Plus, your state's Consumer Assistance Program is a valuable resource for health insurance issues. All right, we've covered a fair bit, but the gist is that the No Surprises Act is here to offer some relief from the headache of surprise medical bills. It's a step towards fairness in billing, but like with any law, the real test is in the enforcement and how well it's followed. Of course, you should still be proactive in understanding your health insurance coverage, including network status of providers and facilities before receiving care, when possible. This isn't a protection under the No Surprises Act per se, but good advice to avoid potential issues. What's been your experience? Ever been hit with a surprise medical bill? Are these protections enough? Let me know in the comments below. Remember to like, subscribe, and share the video with anyone navigating the murky waters of medical billing. I'm attorney Andrew Bethel, and I'm here to help you make sense of the laws that impact your life. I'll catch you in the next video.